Good morning. It is 9:56 a.m. and I would like to call this hearing to order. Let the record reflect that we do have a quorum. There are several members who are attending via Zoom and are teleconferencing. Those locations were posted accordingly pursuant to the Brown Act, and the locations are all accessible to the public. First case before us.
Wait a minute. I'm sorry. I wasn't in the room and I didn't know you guys were. I was trying to help someone out at the desk there, so it didn't capture. I'm sorry.
Okay, so yeah, we'll just take it from the top. Now it's 9:58 a.m.
Hold on, McKay. Hold on. I'm turning it on right now. I'm sorry.
Okay, no problem. Take your time.
Okay. All right. Now you're good. I'm sorry.
Okay, it's 9:58 a.m. past time for the hearing of the South Coast Air Quality Management District Hearing Board to convene. And so we are now in session. I want the record to reflect that 2 members are present in district and at the location within Diamond Bar, and other members are teleconferencing in. Those locations have been agendized and posted pursuant to the Brown Act, and the locations are. Excuse me?
Can you get a little bit closer? It's a little hard to hear you.
Okay, can you hear me now? Is that better?
A little bit. I think so.
All right.
Yeah. Thank you.
Okay, so, all right, so what I was just simply stating is that the locations are in fact able to be accessible by the public. And so we're moving down to, there's 2 cases. I want to just make sure that are there any individuals online providing? Mr. Butler?
Yeah, Ms. Conager, there are only 2 locations identified, one in Florida, one in San Diego. Ms. Conager is, I think, doing it. It's not on the agenda of the location. I believe she's doing under the emergency or just good cause, just cause, all right. So we need to vote on that, and
the people inside the county office that are paid.
My participation is pursuant to the just cause provision under the Brown Act. You do have to agree that it's acceptable to you for me to participate, Madam, Mr. Chair.
Yes. And we were making our way that way. And so is there a motion? I'd like to lay a motion.
Ms. Conager, I'm sorry, before you make the motion, I think you just have to give a reason for the.
I'm participating on government business for another government agency pursuant to the state of California. I am in the Santa Clara office of that agency.
Yeah, and she's provided that comment about 3 times now. So are we good to proceed forward? All right, I'd like to lay a motion on the floor to allow Ms. Conager-Macklin to participate in the meeting pursuant to the just cause provision of the Brown Act.
I will second that.
Okay, it's been moved by Ali, seconded by Ms. Verdugo-Peralta. Any further question or discussion? Dr. Abraham?
Aye.
Ms. Verdugo-Peralta?
Aye.
Ms. Conager-Macklin? She abstains for the record. Mr. Balakapalan?
Aye.
Ali votes in the affirmative. Okay, Ms. Conager-Macklin, you're in the mix. All right.
Thank
So,
you.
Madam Clerk, just wanted to ask if there are any individuals online to provide evidentiary testimony or non-evidentiary public comment.
I don't see anyone with their hands raised, Mr. Chair.
Okay, there's 2 cases on the matter. 2 cases on the agenda. Medline Industries LP case number 6265-1 for regular variance, as well as Beta Offshore Operating LLC case number 5855-7, modification of a final compliance date and an extension of variance. We're going to take 6265-1 first. Madam Clerk, I'd like to mark exhibits, the stipulation of place on consent calendars, exhibit number 1. Rebecca Brown declaration, exhibit number 2. proposed findings and decisions, exhibit number 3, and the communication between Balaka Palan and parties via email thread HB1. HB1.
Madam Clerk, you may want to check the previous minutes.
In the previous minute order, we already had a 1.
Okay, so hold on. So let me reorder. Okay, so that will be your, okay, so the stipulation will be number 2, correct?
That's right.
Okay, so stipulations number 2, Rebecca Brown, declaration number 3, proposed findings and proposed findings in order, number 4, HB1.
No. I'm sorry. That's going to be, because that's not, oh yeah, no, I'm sorry. You're correct. That would be a number 2.
Okay,
I'm sorry.
and then the email traffic between Balaka Palan and parties, that's HB1, correct?
Let me check on the previous one and see if there was another. Yeah, HB1 is right.
Okay, so I'd like to open up the floor for a discussion on this matter. Our motion.
Yes.
Any discussion from members of the hearing board?
Yeah, I'll start. As you know, the matter came before consent and was stipulated, but I had suggested a change which they agreed upon. Just want to remind board members, I think the last time there was some conversation because both parties had stipulated that, you know, the board should not be disagreeing with the stipulation of both parties. But here, I think this is kind of unique, the engine, because the hours reset at the end of the year, and then they won't be, or they will not be out of compliance until they exceed the 200 hours. So that's why I suggested that they request it to the end of the year. If they were planning to still run it next year, then they should come early and get it for, you know, the duration of the, probably till the end of next year. But it appears from the petition, they expected it to be completed by the end of the year, you know, but at abundance of caution, they had asked for a longer period. However, they did agree to accept the date of end of this year, when the clock will reset on all 6 engines to 200 hours. As I indicated in my email, they essentially, because they operate 3 at a time and they switch every, so often 10 days before, they can essentially run it for about 8.33 days before they exceed 200 hours, and then they can switch over to the other engine, set of engines and so forth. But it's entirely up to them how they, you know, plan to do it, and they need to get another variance for the, for next year.
Okay, any further deliberation? All right, I'd like to lay a motion on the floor. In the matter of Medline Industries LP, facility ID number 180785, case number 6265-1. I move that we grant a regular variance commencing November 7th, 2024 and continuing through March 31st, 2025 from the following rules and.
Mr. Ali, I'm sorry. Sorry to correct you before you, it is to the end of the year. I just went through the whole thing explaining why. And if you look at the proposed finding, you'll see it is to, they're requesting to the end of this year.
Okay, so I'm reading the proposed findings, and so I'm looking at the order here.
It's a revised proposed findings.
Okay, wait a minute, let me go back. The proposed.
Are you saying there's another document?
It's in the document, yes. The one we got here, you know, we received, so. I believe it was provided yesterday.
Okay, it on
Page
page 5, yeah, at the top.
Wait a minute, hold on one second. Let me just make sure we're looking at. Okay, fair enough. I stand corrected, and so it will commence November 7th, 2024, and continuing through December 31st, 2024 from the following rules and subsections as encased in Exhibit 4 at the location as encased in Exhibit 4 from the conditions set forth in Exhibit 4 and the applicable fees we pay pursuant to Exhibit 4. Is there a second?
I second.
Okay, Ali moves it and Rodrigo Peralta seconds. Any further question, discussion on that motion? Hearing none. Dr. Abraham,
Aye.
Rodrigo Peralta,
Aye.
Balaka Palama.
Yes, just wanted to add that the excess submission size indicated in the proposed findings.
Yes, Exhibit 4.
And I'll say aye to it, yes.
Thank you, sir. Conager Macklin.
Aye.
Ali votes in the affirmative. This matter is approved unanimously. Down to 5855-7, modification of a final compliance date and extension of a variance. Madam Clerk, we're going to mark these exhibits.
All right, just a minute. Just let me get there. Sorry. I'm there.
Okay. We're marking the stipulation for consent calendars, Exhibit 1.
No,
No, wait a minute. Let me get my notes. Hold on. Okay, so which one should this be? Just want to make sure I'm correct here.
15.
Okay. All right, Exhibit 15 is stipulation for consent calendar. Exhibit 16 is Jeff Ortloff declaration. Exhibit 17, proposed findings and decisions. And then this hearing board exhibit, that would be HB 1, correct?
3.
3, okay, HB 3. Okay. All right, open up the floor for discussion on this matter.
I'll just go and what my email was when they submitted the stipulation for the consent that they had a different date. I mean, they had the same date, but I pointed out it's going over a year. So we're going to have safety code if the variance is over a year, then you have to do a schedule of increment of progress. They revised it and included the schedule of increment progress. So that was the change that I suggested that they make. However, I just want to also, I had previously would know, and I'm going to continue to vote no on this, only because I believe they should have filed as a AOC, not as a regular variance. I think I won't go into all the reasons why I brought that up before. It's on the record. So it's still, I just wanted to put it out there that they should have filed as an AOC because this is a EPA delegated facility and they are supposed to be handled differently than the regular type of facilities. And also that I think we need to be cognizant of the fact if, of timeline, the duration of the variance. We have to look at when the first occurrence occurred. We shouldn't allow businesses to piecemeal it and say, oh, we're only applying for 4-month extension when the duration might be more than a year. Like they indicated, the attorney, they're only asking for 4 months. But if you look at from the first date of the hearing, it's way over a year. That's all I had to say.
Thank you. Appreciate it.
Mr. Chair, I do have a kind of a statement and a question. Obviously, legal agreed to what they are wanting to do, what they're proposing. Otherwise, it wouldn't be on consent. Am I correct?
Yes.
Okay, so I understand what Mr. Balagopalan is saying. However, they didn't do that. They didn't file it in the way that Mr. Balagopalan described, and obviously legal is okay with it. So if they are okay with it and it's a matter of, filing one way or another. I do understand what Mr. Balagopan is also stating in reference to the timeline, and I would have liked to seen the timeline, which I don't think that they submitted. Is that correct, Madam Clerk? There was no timeline. There was no document of a timeline. So I think that the only real choice here is to go forward, and I'm going to support this.
All right, no problem.
Just to clarify, I'm only opposed, just for the record, that it should have been AOC right from the beginning.
Mhm.
I think this project is it's really is a beneficial project. They are removing the engine, they're going to electrification. It's taken longer than they proposed. So it is a win-win situation for everybody with this proposed changes that they're making for electrification of the unit. So I'm not saying any on the merits of the what has been the case. I'm just saying, and I've registered. I just in the very first hearing, I registered my objection that it should have been done as a AOC. So I'm just continuing. That's all. I'm not so.
No, I understand that.
Okay, that's all. So
yeah.
that's and the change that I did make, even though I was going to oppose it, and for the record, but I wanted to make sure that the board members are aware that they should have done incremental progress, and they did it, and they corrected it. And if you look at condition, they listed it as 15 and you'll see that, or is it 5 and 7? 5 and 7 will condition 5 and 7 will serve as schedule of incremental progress. So they did revise it at the changes. So they did that in the red line version. They indicated that. So they did that. So they'll have to meet now the schedule of incremental progress. If they don't meet, then they'll have to file again a request and modification.
I did see that, and that's why I think that they are attempting to comply with what we ask of them. And as you said, as long as they go ahead and they follow through with those conditions, I don't see why we wouldn't support it.
All right, I'd like to entertain a motion in this matter, in the matter of Medline Industries LP, case number 6265-1, facility ID number 180785, located at 1960 West Miro Way, Rialto, California, 92376. I move that we find good cause to grant the request for extensions, modification as set forth in the proposed findings and decision exhibit 17, full stop. Is there a second?
Second.
It's been properly moved by Ali and seconded by Dr. Abraham. Any further question or discussion on the motion? Hearing none. Dr. Abraham.
Aye.
Verdugo Peralta.
Aye.
Balaka Palama.
No.
Conacher Macklin.
Aye.
Ali votes in the affirmative. The matter is
I'm sorry,
approved 4-1.
Motion.
Excuse me?
Nothing.
Excuse, do you have the motion clear?
Yeah.
Okay, good deal.
Yes.
All right, I'd like to adjourn this meeting at 10:16 a.m. and we are off the record.